and the court secondarily to come up with rights good against state governments. But I don't think it's actually nearly as important an issue. The Justice Black always said he thought in his dissenting opinion in Adamson that the Section 1 of the 14th Amendment, taken as a whole, including all of the clauses meant to apply the Bill of Rights to the state, that's never been accepted. I think the court is now fully accustomed to looking at this as a liberty clause. And unlike almost everybody else, I don't think it's as oxymoronic to speak of substantive due process in the following sense. When the clause says that liberty and property cannot be abridged or impaired without due process of law, part of the concept of due process of law was that there has to be a public purpose. For example, a legitimating public purpose, or else it's an arbitrary imposition. Taking from A the property and giving it to B would have no public purpose and be such an arbitrary imposition. So I've never felt that the kind of rights that were perhaps more naturally intended to be protected by the Privileges and Immunities Clause, I don't find the home for those rights, whether they're property rights or individual liberty rights, to be so alien to the way in which the Due Process Clause reads, since an imposition in law which is arbitrary and advances no legitimating public goal, I think doesn't deserve the encomium due process.
Anybody else want to talk about the gun case or that specific issue?
I guess I'd just say I think it would be much more intellectually satisfying if the court incorporated the Second Amendment and indeed all of the amendments via the Privileges and Immunities Clause, but I don't think they're going to do that at this point. So,
I have a follow-up question. It's actually related. Looking at the context of the 14th Amendment, we have the Civil Rights Act of 1866 and the controversy over the constitutionality of that. Many people in the 39th Congress felt that the Section 1 of the 14th Amendment was merely just to constitutionalize that act. How would you feel that, in light of we have Section 5, and we have later statements by John Bingham that Section 1 is not self-executing. Do you feel that the relationship between Section 5 and Congress, or as the judiciary is a secondary role, that the judiciary should be interpreting initially privileges and immunities over something that comes from Congress under Section 5?
To me, I think the most fundamental era that I believe, and from my standpoint, there's very few here will agree with this, of the last 20 years is the reduction of the role of Congress under the 14th Amendment, that it was principally intended to empower future Congresses, and the notion that Congress has to dance to the proportionality and congruence made-up language of, the court seems to me to be, fundamentally an error, that this was designed to empower future Congresses. Justice Black, I said, the reason that the incorporation theory appealed to Justice Black, everybody saw it for a, quote, liberal move, that he would in one fell swoop in 1947 incorporate all of the provisions of the Bill of Rights and make them applicable to the states. For him, equally important was that would be the limit of it. He was very troubled by the open-ended invitation, or indeed almost obligation of the courts to define what are privileges, what are immunities, what liberties deserve fundamental protection. And he thought by grabbing the Bill of Rights, he would both protect all those rights and limit it. These and no more. That's all it meant in his view. And Justice John Marshall Harlan, who is usually thought of in some senses a more conservative justice who rejected that, thought that none of these amendments were incorporated, but that even they wouldn't be the limit of liberty in any event. See his dissenting opinion in Poe versus Ullman on the protection of birth control. So Black saw incorporation as a rigid way to protect the rights, a set of rights, and go no further.
Anyone else? I was wondering if some of the other panelists might want to respond, particularly maybe you, Walter, about whether Justice Sotomayor repudiated the president's qualifications for picking judges and justices.
I'm not sure that empathy was the best word, and certainly someone who is up for a confirmation doesn't want to say empathy in it. And it certainly, I mean, there's nothing that senators of all parties love more than to say that you're going to apply the Constitution exactly as written, which is very, very appealing to those who have not read the Constitution. But when you see the open-ended language, at the very day, I think, that she said that, her hearings were going on when the court was deciding cases, was opinion by Justice Scalia that was full of discussions about what makes sense as a matter of policy and the operation of government. I mean, you know, I think that everybody is running from what the president was saying because there's such a sense out there in the country that this is an exercise like Euclidean geometry or mathematics or logic. But I don't think anybody really believes that judgment is not deeply involved, whether it's the judgment about the need to protect, commerce from Lilliputian local regulation or whatever. People bring some sense to these things, whether it's empathy or hostility or meanness or whatever it is, you bring something to it. And I think having some, that's why I thought that's a retreat into formalism that I don't think any of us really believe is how courts operate or should operate, that these matters can be decided as a matter of logic. Judges would be like umpires, I once wrote. Judges would be like umpires or umpires would be like judges if the game said each team shall have a reasonable opportunity to score runs, and that's the only rule, but that's how open-ended constitutional language is, which is why the exercise requires judgment, which is, I think, why they're called judges and not umpires.
I think if you look closely at what now Justice Sotomayor said in her confirmation hearings, the level of legal formalism was really taken to a degree you've probably never seen before. In particular, she kept saying, "I will apply the law, not make the law. Judges should not apply the law. They should apply the law, not make the law." If you look closely at everything she said, I think it's fair to say that her view was if a court did it, it was an application of the law, not a making of the law. And if a legislature did it, it was a making of the law, not an applying of the law. So actually, it was entirely circular when she was saying, "I will apply the law." That meant she won't go to Congress and vote as a senator. She will be wearing robes. And I'm not actually exaggerating. If you look at all the testimony, including the written testimony, she comes pretty close to saying if it's a court, it's applying the law. So I think the words she used were very carefully designed to leave the impression that she was, if not maybe a conservative judicially, certainly not somebody who was going to render any sort of odd rulings. That was sort of the impression that was designed to leave. But if you look closely at the language, the words were very carefully chosen.
Policy. Sorry.
Well, I think